Hello everyone and welcome back to the channel. Hope you're all keeping well, and welcome to a standalone episode looking at the issue of hearsay. And you may have remembered, if you haven't watched any of the videos on the criminal litigation process, I've made 10 separate videos looking at the journey of a criminal case from arrest and charge all the way up to sentencing and appeal. And one of the episodes, Chapter 5, looked at criminal evidence and burden of proof. It's a fairly detailed episode. I think it was over 30 minutes. And a number of you have actually watched that since. And thank everyone who has watched that and subscribed. But we only really touched upon the issue of hearsay. And this is quite an important element of the bar course, but also it's found its way into the English language as a generalized phrase, hearsay. So we're going to have just a snapshot and dive a bit deeper as to what hearsay is in the criminal context. So today we're looking at one of the most misunderstood but fascinating areas of criminal evidence, and that's hearsay. Under Section 115 of the Criminal Justice Act 2003, hearsay means a statement not made in oral evidence at trial, but relied on as evidence of any matter stated. But simply, it's second-hand evidence. So if someone tells the court what another person said, not what they themselves saw or heard, that's hearsay. The problem? Well, the original speaker isn't in court to be cross-examined, so we can't test whether what they said was true. If you go back to Chapter 7 inside a criminal trial, you can see we touched upon it with the expert evidence as well. Sometimes the case only unravels once the witnesses are on the stand and once they've been probed and questioned on the strength of the evidence through cross-examination. So it's very important to have the opportunity to critique the strength of the evidence by bringing the person into court and questioning them. And the problem with hearsay is that doesn't take place. So that's why hearsay is generally excluded. But as we'll see, there are important exceptions to the rule. So the general rule is simple. Hearsay is inadmissible in criminal law unless it fits one of the exceptions set out in the Act. The logic is all about fairness. So evidence must normally come from the witness directly. Someone who can take an oath, be seen and be questioned. And if the court allowed every "someone told me" statement, the trial would lose reliability and the defense would lose the right to challenge it. So hearsay starts from a position of exclusion, but the modern law is more flexible than people often think. So Section 114, subsection 1 of the Criminal Justice Act 2003 provides 4 gateways through which hearsay can come in and be admissible. So A statutory provision, like sections 116 to 118 of the Act. B, reserved common law exceptions. We will go into a bit more detail on some of these later in this episode. Don't worry at this stage. Section C, agreement of the parties. So if both parties, the prosecution and defense, don't object for it to be in there, then that's perfectly fine. They've agreed for it to be in and they can allow it. And D, one of the most important ones, if not the important, the interests of justice test. And we'll have a look at that in this episode. So judges keep a tight rein on these gateways, ensuring that fairness and reliability are maintained. Think of it as the legal equivalent of a controlled access pass, so only certain statements make it through. So the most common gateway is Section 116, and this covers witness unavailability. So remember, we talked about the general rule. The preference is to bring the witness into court, whether that's inviting them or a summons, and so that they can be cross-examined on the stand. But what if the witness is unavailable? So this potentially opens an avenue or a gateway, so to speak, for hearsay to be admitted. So a statement can be admitted if the witness is identified and one of the 5 conditions in section 116, subsection 2 applies. So either the witness is dead, they're unfit through illness or incapacity, they could be abroad, can't reasonably be brought back in time for the trial, they cannot be found, maybe, despite reasonable efforts, or they could be in fear. So depending on the type of case it is, they could be in fear, and the court considers it in the interest of justice to admit their statement. And under section 116, subsection 4, the court weighs up the necessity, reliability, and fairness. For example, if a terrified victim's original statement is detailed, recorded, and corroborated, the court may let it in. If it's vague or untested, it's usually excluded. Just on this point, if you remember, we touched upon special measures, and if there is anything that can be done to alleviate the fear of a witness, whether that's putting a screen up, escorting them in and out of court, then these should also be explored first. Next, we have section 117, so we have business documents. And section 117 allows hearsay where the information comes from records created in the course of a business, as long as it's routine and reliable. For example, a supermarket record showing the time a card was used, or a phone company's log showing call data. These aren't statements for trial, they're neutral records made during ordinary activity of business. But there are conditions. The document must be made by someone with personal knowledge or by a chain of people acting in the ordinary course of business. If the information looks manufactured for litigation, it won't qualify. And I do urge people who are studying the course to go look at this section in detail for their examinations and a better understanding. Section 118 preserves a few common law exceptions. The most common for the bar course is res geste, or spontaneous statements made during or immediately after an event. For instance, imagine a victim shouting, "He's got a knife, he's got a knife," while running away. That's admissible because it's in the moment, during or immediately after an event. Why? Because it's spontaneous, leaving no time to invent a lie. So there's no delay in concocting another version of the story. It's spontaneous, it happened, it forms part of the event itself. Section 118 also covers public records, things like official registers, certificates, or entries made under legal duty. They're admissible because they're official, verifiable, and created without bias. So this section keeps a few long-standing exceptions alive, especially those where human spontaneity or official reliability carry natural trust. Now, what about multiple hearsay, a statement passed from one person to another, then to another? So we've already touched upon the unreliability of hearsay, but what happens if it's further hearsay by passing from one to another to another? So under section 121, the general rule is that multiple hearsay is not allowed. It's considered too unreliable. For example, person A tells person B what person C said. By the time it reaches court, it's third hand, with no one left to test the truth at each stage. There are limited exceptions, such as when it fits within another statutory gateway, or when all intermediaries are unavailable but identifiable, or when it is in the interests of justice to admit it. But in practice, courts rarely rely on it. Every extra link in the chain makes the evidence less trustworthy. So we've talked about the interests of justice. So the interests of justice test, the court's safety valve under section 114, subsection 1, subsection D. This is where the judge has discretion to admit hearsay, even when no other rule applies, but only if it's both necessary and reliable. And under section 114, subsection 2, there are 9 factors the court must consider. So if you are studying this area of law, then do recommend you go and memorize and learn these. But just to summarize how important the statement is, how reliable the maker is, the circumstances it was made, how easy it would have been to test it, the reliability of the evidence supporting it, the risk of unfairness to either party, how much weight the statement carries, whether the maker can give oral evidence later. And during the bar course, you will actually touch upon an alternative to hearsay would be like a remote link, if that was deemed appropriate. So there are other ways to give oral evidence, and then also a deposition is another way. So look into that. So there are other alternatives, and also any other relevant circumstances. So this test gives the court flexibility, but it's used carefully, only where excluding the statement would risk injustice. For example, a dying declaration by a victim with no time to lie might be admitted, but a rumor from social media would not. So that's hearsay really in a nutshell. It is a very complex area of law which does take a dedicated amount of time to do further reading. This is only a snapshot, but for students it's about knowing the gateways, section 114 through to 121, spotting how the courts balance reliability with practicality. For the general public, it shows the criminal courts don't just chase truth at any cost. They follow structured safeguards to ensure fairness and accuracy. So I hope you found this helpful. If you did, please do hit like, subscribe, and drop any questions in the comments below. I do try to read all of them and try to answer them as best as I can. And we will make some further videos on standalone areas of law, things like bad character. That's another video we're going to come across soon. But hopefully you enjoyed the video. Thank you for watching. Hope to see you on the next video. And bye-bye for now. Take care.